Hi everyone, this is Thomas Horton, barrister at Three Hare Court, and this is the first podcast from Three Hare Court sports law team. And these podcasts are something that the sports law team are looking to do on a regular basis. And we have a very interesting first episode here for you. I'm joined by Daniel Black, barrister at Three Hare Court, and he will be discussing recent events concerning the liquidation of Rangers Football Club, and in particular the wrongful prosecution of two of the administrators involved with that process. Once Daniel's finished talking on that topic, I will then also be discussing the recent winding up of Macclesfield Town Football Club and what the consequences are of that winding up order being made against them. So without further ado, hi Daniel.
Thank you, Tom. Well, as the listeners can probably tell, like me, this story starts north of the wall. To understand the picture, really, we have to go back to 2012, when the Scottish newspapers bore headlines such as the Daily Record's RIP Rangers. The reason was that after about 20 years of at times considerable footballing success, certainly domestically, Rangers were running out of road in respect of their now infamous financial troubles. These ultimately led, as is well known, to liquidation. Anyway, along that path in February 2012, two men by the names of David Whitehouse and Paul Clark were appointed as administrators of Rangers. I should note at this stage that both men had left their positions prior to liquidation. So why the sporting legal interest now? Well, Whitehouse and Clark, the pursuers, as we call claimants in Scotland, have that capacity because of what's fair to say is a dramatic set of circumstances and alleged circumstances. Following their appointment as administrators of Rangers, and this was by the then Rangers owner, Craig White, the police came to be instructed to investigate Mr. White's initial share acquisition of Rangers. Now, as part of that process, the police obtained a warrant to search the administrators' offices in London and in Manchester. Documents, including privileged items and others outside the scope of the warrant, happened to be taken as well from the search of a connected law firm, and these were actions which in turn led to rebukes in the Scottish and English courts. In the event, the men were in fact arrested, and they were arrested on Friday the 14th of November 2014. These arrests were effected at their respective homes, those being in Cheshire and in Surrey, and these were done by officers from Police Scotland. Both pursuers were taken to Glasgow, and they were separately interviewed, arrested and charged. The charges were fraud and perverting the course of justice. They were in jail, in police custody, rather, over the weekend until Monday the 17th of November. They were then granted bail at Glasgow Sheriff Court. At this stage, they were provided a summary of the evidence against them. The alleged false pretense was that Mr. White was a wealthy man who was investing his own capital, when in reality, he was using money advanced to Rangers in the anticipation of season ticket sales. The practical result was alleged to be that Mr. White had gained control of the club and forced it into administration to the financial benefit of the pursuers. So, you know, pretty strong stuff. Anyway, in June 2015, the pursuers' legal advisors were told that the focus of the inquiry had changed. Any subsequent indictment, they were told, was likely to include charges relating to the conduct of the administration itself and the disposal of Rangers' assets. Mr. Whitehouse was then again detained, and again at dawn on the 1st of September. Mr. Clark was not. He happened to be on holiday, and the attempt to detain him failed. However, having heard of the same, he returned to Glasgow and went to his solicitor's office, whereupon he was detained. Both men were re-interviewed, re-arrested, and charged. The pursuer's position was that there was never any justification for the detention, the committal, the prosecution, or the indictment that were put on them. Now, where we pick up the story again is that the charges were dropped. And when they were dropped, the two men alleged that the Crown Office, that's the prosecuting authority in Scotland, and the police had subjected them to wrongful detention, arrest, and prosecution. So it was that around a year ago, both men found themselves in the inner house of the Court of Session, claiming damages against the Chief Constable of Police Scotland and the Lord Advocate. This was to be compensation arising out of their treatment by the police and the prosecution authorities in connection with their involvement in the winding up and sale of Rangers. Now, I should note at this point that being in the inner house of session means that the inner house of the Court of Session, rather, means that this was an appeal from a first instance decision being in the outer house of the Court of Session, which I shall touch upon shortly. Importantly, the men, as you have heard, also brought the claim against the Lord Advocate. Now, for those without Scottish ears, the Lord Advocate is the head of the systems for the prosecution of crime in Scotland. For English ears, that means he has some similar functions to the Attorney General here. Anyway, in due course, the Lord Advocate accepted that he was responsible for the actions of the relevant prosecuting authorities. And pursuers, therefore, had their action. The primary bases were that the pursuers alleged their prosecution was in breach of Article 5 of the European Convention on Human Rights, and that their prosecution beyond the initial hearing was malicious within the meaning of Scots law. I referred to the outer house of the Court of Session a moment ago, the first instance court, and this is where the legal intrigue really picks up. At first instance, the inner house had held that the Lord Advocate could not be liable in damages for acts which are malicious and without probable cause. This, it was said, was because the office holder had absolute immunity from suit in connection with proceedings on indictments. The reason for this outcome was that this had been the ratio of a rather flimsily reasoned, if it may be said, 1961 decision of Hector against MacDonald. The inner house of the Court of Session, however, on appeal reversed this, and, tracing the issue all the way back to Roman law, held that Hector had been wrongly decided. The pursuers, who claimed substantial millions, could therefore sue the Lord Advocate, as well as the police. And there was still more drama. On the 27th of August this year, the outer house of the Court of Session, to where the case had returned, awarded the pursuers an interim payment of £600,000. Now, the reason for this was that the Crown had changed parts of its position. In particular, the Crown admitted liability for wrongdoing in parts of its prosecution. Specifically, it was accepted that the treatment of Mr. Whitehouse and Mr. Clark during the prosecution was in breach of Article 5 of the European Convention on Human Rights, and that the prosecution, beyond the initial hearing, was malicious. The result? As of September 14th, the Crown's position is now that the pursuers will be compensated on the basis that they should not have been prosecuted at all. As Dean of the Faculty of Advocates, Roddy Dunlop, Queen's Counsel, who acts for Mr. Whitehouse, put it, the Crown accepts responsibility for their liability for the consequences of the prosecution against these gentlemen. There really is so much here. For those who are interested in the legal aspects, more interested in the legal aspects than the sporting aspects, there's a very interesting article by Dr. Bobby Lindsay in the Edinburgh Law Review on this, which gets into comparative issues with English law as well. And for those more interested in the sports angle, keep following the news, and I suspect as well, keep following my colleague Tom's sports law website, where I dare say the ultimate sum of compensation awarded to the pursuers will be reported.
Thanks for the plug there, Dan. I appreciate it. Yeah, it's footballlaw.co.uk for any of you that are interested, or at the Football Law on Twitter. And I'm sure I will be tweeting about that once the final assessment of damages is determined. And Dan, it just seems, from the administrator's point of view, they must have felt so affronted to be in the position where they think they're doing all that they can for the club and the creditors, to then subsequently face these sorts of charges. I say the affront of that to them must have been great.
Yeah, absolutely. And ultimately, when any office holder is discharging the duties of their office in the appropriate course, it would be a horror show to have these sorts of accusations put against you, especially, it would be fair to say, I think, in the context of, in Scotland, what was a national, certainly a national piece of news. You may even go so far as to say a national scandal, the demise of Rangers. So, I mean, the pressures on the men must have been absolutely immense. I completely agree.
And as a sort of a comparative point as well, and this would be something that I touched upon when discussing Macclesfield, for the administrators to have been pursued so aggressively to begin with, it's in stark contrast to what you normally see with football clubs when they enter administration or liquidation, where so few cases appear to be brought against those directors for their actions, which essentially resulted in the company that owns the sporting body going into administration or liquidation in the first place. So I think that's quite an interesting comparison to make, and how quickly the administrators were pursued, but you don't tend to see that with the directors themselves, either for damages for the insolvent or company in administration, or for a director's disqualification order as well.
Yeah, exactly. What I think will be interesting in that respect is how the public mood might change moving forward now, and whether that changes the way that these matters are pursued legally, because football, whilst it's going to go through a lot of difficulties like the rest of the economy just now, it may be that an industry which has so much money in it, it comes to have less public sympathy moving forward, and that may influence the sort of actions which are brought. Of course, it may not. And in that case, in that sense, we are speculating on what cases may be, but certainly I think it's founded speculation, and it's an interesting one to watch over the coming months and years ahead.
Absolutely, and as Macclesfield recently being wound up demonstrates, and with Bury last year, and over the past decade, a number of clubs going into administration. This isn't something that's uncommon, and is undoubtedly going to be a topic that arises, in the near future, particularly when we're looking at clubs as well, facing so many difficulties and obstacles following the COVID pandemic, and whether leagues can actually take place. I know in the National League, for example, there's a lot of concern. But who knows what could happen to even the higher leagues in the coming months if things aren't properly dealt with.
Yeah, exactly. And the industry certainly below the Premier League clearly had financial challenges anyway, in terms of moving forward and capturing the young generation's attention as an audience, and how that ties into whether the large television contracts, which really have been the bedrock of the finances in football now for some time, can continue in respect of the lower leagues. So it is going to be incredibly interesting to go forward. It's where the action is going to be, I think.
Off the pitch rather than on the pitch, unfortunately. Well, talking of action off the pitch, Macclesfield Town Football Club certainly provided a hell of a lot of that over the past year or so. And Dan, I'm sure you saw yourself that last week, the 16th of September, announced that they'd been wound up by Judge Prentice in the High Court.
Yeah.
And it's a tragic circumstance for a club that's been in existence since 1874 for, just for the case of recent financial mismanagement, that tradition and that real centre of community, has been talked about a lot since the winding up was announced, has almost been lost so easily. And it's all sort of stemmed back, as I said, in the past 12 months or so. And it's been mingled in with all of these disciplinary or misconduct charges that Macclesfield Town have also had to face, which go back to November 2019. For example, there were a lot of issues being discussed between Macclesfield Town and the EFL in respect of Macclesfield's non-payment of players' wages. And this was a common occurrence throughout that 2019-20 season, and resulted in many misconduct charges being brought by the EFL against Macclesfield, but also resulted in players refusing to play on some occasions in protest of their non-payment, which in consequence then resulted in Macclesfield being unable to play football matches, which then again in consequence resulted in more misconduct charges against the club for being unable to fulfil its fixture requirements. And then even as the club and the EFL generally dealt with the coronavirus pandemic, and the EFL provided some loan facilities to some EFL clubs, there was even an issue and a misconduct charge in respect of the way that Macclesfield Town had used a loan given to the club by the EFL, but by not using that money immediately to pay off players' wages that hadn't been paid, and other wages due to staff at the club as well. And what it all came down to was that over the course of that 2019-20 season, Macclesfield Town had collectively been deducted 13 points, which for any club in any league is going to be a drastic measure for them to have to deal with. And I think even if you've got mediocre to good form, you're going to be in dangerous territory with relegation as a possibility. But even when the club was faced with a 13-point deduction in total, the final decision at that point, so we're looking at June of last year, there was a final decision that determined that there was 13 points in total. However, the EFL then appealed against that final decision, and which saw the 13 points stand as in total altogether, but then there were also an additional 2 points, an additional 4 points implemented against the club as well. Those additional 4 points had been suspended previously, but came into effect following the appeal made by the EFL. And the consequence of those additional 4 points being applied in the 2019-20 season was that Macclesfield Town were relegated to the National League. So, irrespective of all these issues that resulted in the insolvency, although they are tied in some respects, the club had already been put through the ringer in terms of all of these misconduct charges relating to payment of players' wages and not fulfilling fixtures and not using a loan provided by the EFL correctly. And I can completely understand, I think Macclesfield Town's fans' frustration with those additional 4 points taking effect in the 2019-20 season, and which resulted in the club's relegation. And in particular, because in recent decisions involving championship clubs over the past year or two, notably Birmingham City and Sheffield Wednesday, Birmingham City received a 9-point deduction for its breach of the championship's profitability and sustainability rules, and it received a 9-point deduction in the relevant season that the decision was made. But more recently, and referring to some of the considerations in that Birmingham City case, the case against Sheffield Wednesday, which is something that I've discussed on the website footballlaw.co.uk, and some podcasts and other interviews which are all linked on that website, saw Sheffield Wednesday receive a 12-point deduction for its breach of the Championship's profitability and sustainability rules. But there was a particular consideration from the Birmingham City case and other factors, which was that relegation or promotion being affected by a points deduction in the last few weeks of the season was deemed to be far from ideal. And it was that sort of consideration in the Sheffield Wednesday case, amongst other factors, notably delays caused to proceedings from COVID, which caused the points deduction to take place from next season, or I suppose this season now. And when you consider those sorts of points, and you compare that to Macclesfield Town, and they'd already had, as I say, a lot of points deducted from them throughout the season, you can understand some of the arguments that it's a bit unfair that they should have those additional 4 points that cause them to be relegated. But one distinguishing factor, I think it does carry a lot of weight, I suppose, much to the disgruntlement of Macclesfield Town's fans and the owner, I'm sure, is that because there have been so many repeated instances of misconduct by Macclesfield throughout that 2019-20 season, as I said, be it non-payment of players' wages on numerous occasions, non-fulfilment of fixtures, and the misuse or not using that EFL loan immediately as it was supposed to have been done. All of those repeated misconduct charges were aggravating, is what the League Arbitration Panel determined, and in such circumstances applied that additional 4-point deduction, which caused Macclesfield to be relegated. So you've got that occurring just a couple of months ago, last month even. That League Arbitration Panel decision was announced on the 11th of August. And then just over a month later, as I said, the 16th of September, the club is then compulsory wound up by Judge Prentice in the High Court. And you just feel like things are getting from bad and definitely to worse for the club. And I think there's at least from the fans' perspective, there's a bit of confusion as to what is going to happen to the club now that winding up order has been made. And Dan, I think you'd agree that once the winding up order has been made, things are quite bleak for a company or a club generally.
Yeah, absolutely. And unfortunately, it does seem that this is something which is going to be affecting more football clubs moving forward. Now, arising from what you were saying there, Tom, actually, I do have an interesting interest in your thoughts on this. So I noticed that Judge Prentice had said that he could see nothing which gave him any comfort in terms of Macclesfield's ability to survive. And I noticed that the chairman of Halifax, Mr. Wilde, had said that more clubs are required to live within their means. Now, I suppose where I'm interested in your thoughts on this are how, or even is that possible in a financial fair play era? Because there'll be a lot of clubs who, in theory, could be supported by a single investor. But that seems to throw up all sorts of difficulties now with the regulations as perhaps as they stand.
Yeah, so there are a few points to address in there, and I think that first one of what Judge Prentice says, that there was nothing that gave him any comfort that Macclesfield Town could continue and could pay its creditors to avoid the winding up order. One of the sanctions that was made against Macclesfield throughout all of the independent disciplinary commission hearings and the League Arbitration Panel hearings as well, was that towards the end of all of those proceedings, Macclesfield were ordered to provide a business plan, and that business plan was to explain, what exactly the club is going to do going forward to bring its finances in order, and how it could, satisfy its requirements going forward as well. Now, reportedly, that was given by the club to the EFL on the 31st of July, but there's been no reference from what I can see in the reports following Judge Prentice's decision to identify that business plan was given to the court to consider, or indeed to any of the creditors to consider. And there was no real comment from the EFL as well, whether that business plan was viable or what it even entailed. So completely appreciate Judge Prentice's comments, and he's obviously made them upon what was before him on the day of the hearing, but it would have been very interesting to see what that business plan entailed, and whether it was just a foregone conclusion from that business plan that Macclesfield Town were inevitably going to be wound up. And then going on to that point from clubs living within their means, it's absolutely, I think, not uncommon for clubs or their existence to be dependent upon capital injections from its owners. I've looked through various clubs' financial statements on Companies House, and very regularly you will see that the owner has had to give cash injections, and that is as a sort of a common practice, and the club's viability and ability to comply with its financial requirements is needed, whether it be paying players' wages or just general expenses of the club. And we've now moved into an era with League One and League Two clubs in particular, where they're now operating under the new salary cap, which is something that I've also discussed on the Football Law website, and I'd urge everyone to have a look at that and what those new salary caps entail. But there is hope, I suppose, that with those salary caps coming in and stopping the spending on players' wages, for example, being so excessive, that clubs can now be in a position to live within their means more so. But it's in a very nascent stage, and the financial fair play rules that the EFL have implemented in the past haven't been always that successful. I think Macclesfield and Bury and other examples speak for that itself. So I think it's a matter of waiting and seeing how clubs can work under that new salary cap. But I think the bigger problem is definitely going to be, as things are, clubs having to operate with considerably lower revenues in the absence of fans being there watching the matches. So it's going to be interesting, but I think for all the wrong reasons. But nonetheless, I think you touched upon this, Dan. These sorts of discussions are therefore becoming ever more necessary and important to have about what are the ramifications for liquidation for a football club. Because I think a lot of people are reporting that this is just going to be something that's going to happen more so if things don't change within the next 6 to 12 months. And just going back to the situation with Macclesfield in particular, there's been, quite strangely, no statement released from Macclesfield itself or from the National League in respect of Macclesfield being wound up. So it's not really known what Macclesfield's or indeed the liquidators' intentions are in respect of the club, or for example, what sanctions are available to the National League in respect of Macclesfield being wound up as well. I suppose, focusing on the club to begin with, there are some options open to Macclesfield to try and stop things if they think the liquidation shouldn't proceed, or that there was something wrong with the decision that was made by Judge Prentice. There are a few options available to them. So firstly, I suppose, Dan, I'm sure you've seen these before with your time in the High Court and your time at Chambers already. They could apply to rescind the winding up order. Well, I say they could. If any application to rescind the winding up order is going to be made, it has to be made by a creditor or the company jointly with a creditor. But one factor that I've noted in respect of any such application being made to rescind the winding up order is that would need to be made within 5 working days. And bearing in mind that the winding up order was made on the 16th of September, I think today, the day that we're recording, the 25th of September, is the last day that application could be made, albeit there is a remote possibility that you can apply the Denton principles and try and make an out-of-time application. But even if an application is to be made, the possibility of being successful are quite slim, as Macclesfield Town or the applicant would need to demonstrate that the circumstances are materially different now from the time that the winding up order was made. But as I say, in the absence of any statement being released from Macclesfield Town, there's really nothing to suggest that is the case. Another option for them as well is to perhaps look at making an application to stay the liquidation. But again, such application can only be made by the liquidator or the creditors involved. And the effect of a stay would be to stop the liquidation in very simple terms. But this is, again, something that's at the discretion of the court, but would only usually be made where the company, i.e. Macclesfield Town, or the creditor can, or the receiver can demonstrate that it is solvent, or that there's some form of public interest in the stay being granted. And if a stay is granted, it can be permanent, so the liquidation just doesn't happen, or it can be for a limited time and made upon such terms and conditions as the court thinks fit. And one interesting point about making an application for a stay is that there's no time limit for the application. So say, for example, within the next few days, there was a company or an entity or a person who was looking to, say, rescue the club in some respects, or if there was funding available, this could be something that could be a saving grace for Macclesfield Town. But again, without any notification from the club as to what's happening and what the circumstances are, again, there's nothing really to give much hope for that being the case.
Yeah.
The final avenue for them to consider in respect to the winding up order is to make an appeal against it. But again, going back to this point of there's been no statement released, there's nothing to suggest that Judge Prentice's decision was wrong or that it was unjust because of some procedural or other irregularity. So I don't think that one warrants much discussion, because I really can't see that possibility getting off the ground for the club. So from an insolvency perspective, there are options open to Macclesfield Town, or I suppose in particular the liquidator and the creditors in particular, working in conjunction with the club to try and stop that liquidation if possible. But it's all very circumstantial, and until we hear anything further, it's anyone's guess what is going to happen or what could happen. And then also looking from the National League's perspective, I've had a look at the National League standardised rules, and they have, much like the EFL does with their regulations, it provides for certain sanctions to be applied when it comes to an insolvency event taking place. This was something that, for example, that was seen recently with Wigan in the EFL. And the National League standardised rules state that where an insolvency event occurs, so for example, being wound up, the club would be deducted 10 points. So again, it's just almost a tragedy for the club that even if it is able to continue playing next season, it's already going to have a 10-point deduction. But strangely, there's been no comment or notification of that from the National League as things stand. And also there would be an embargo on player registration. Although I'm aware that Macclesfield Town had actually, I think, signed around a dozen players before the winding up order had been made. So maybe they got their house in order in that respect before the winding up order was made. Beyond that as well, there are provisions in the National League standardised rules that allow for, say, for example, a sort of Phoenix club was to be created. There are possibilities in the National League standardised rules which would allow for the transfer of Macclesfield Town's membership of the National League to a new entity. And I suppose, if that avenue is being looked at from, a separate organisation looking to, keep Bury alive in some way, that is something that would be considered, and whether that new entity could take Macclesfield's place in the National League. But I say it's quite strange that there hasn't been any statement or notification or comment generally from both Macclesfield Town and the National League. But you'd hope there would be something, very soon, particularly as the National League season is due to start on the 3rd of October.
Yeah, definitely. I think just to touch on a couple of the points you made there. I mean, speaking about trying to rescind the winding up order. The difficulty really, or one of the difficulties, but especially in the current context for football clubs, is, as you identify, the 5 working days time limit there. And in circumstances where Judge Prentice has said that he can see no comfort, that things can change going forward, to be able to show that circumstances are materially different within 5 days, especially for clubs who are not going to be able to get fans through the stadium for at the very least 6 months. It seems to be a bit of a flight of fancy, as sad as that is, and it may well be that that rather sad thing that happens when you Google a football team and you see the Wikipedia link at the side of the page that says X was a football club, may just be something which we're going to get used to.
Absolutely, it is very sad, and my sympathies go out to all those associated with the club, whether it be the players, other staff, and of course the fans as well. But we've touched upon it. I fear this won't be the first time that this sort of circumstance is going to be discussed on Three Hair Court Sports Laws podcasts in the future.
No, sadly, I have to agree.
Well, thanks, Dan. Very interesting stuff about Rangers, and I hope you found the Macclesfield Town stuff interesting as well. There's going to be more podcasts coming in the near future. One set up already with me and Julia Lois, which will be discussing the return of sporting events with fans, or I suppose not returning with fans, and how government guidelines are being implemented in respect of the same. So do please keep an eye out for that. And I hope you've enjoyed listening to this podcast. Thank you.